All rise. The Court of Appeals, Division 1 is now in session.
Be seated. Now is the time set for oral argument in cause number TX2016-000324, State of Arizona, Arizona Department of Revenue versus Carl Tunberg et al. For everybody's information, as is typically the case, these proceedings are being audio and video recorded and live streamed. So if we can get technology to work for us, you can probably critique yourself in a couple of days, or a couple of weeks, excuse me, but I'm sure you know how to do that. Counsel, each side will be entitled to customary 20 minutes. We would ask that you respect that time period, and we will hold it to it as need be. The timer located on the podium will let you know how much time you have left, and for the appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can help you, or try and help you, avoid taking up all of your time. However, ultimately, reserving that time is your responsibility. We've reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and issues attendant to this argument, and we tell you that so you can figure out how you want to use your time in regard to facts or law, what it is you think is the most important. Counsel, when you come to the podium, I would ask that you state your name and for each of you who you represent. And with that, appellant's counsel, you can begin.
Before you begin, I apologize. I'm the reason we are late today. So.
That was not anticipated. So go with it. We won't take that off your time. How's that?
Appreciate it. Your Honors, may it please the Court, Lauren Stein appearing on behalf of the appellants Carl and Danette Tunberg. I'd like to aim for reserving approximately 5 minutes for rebuttal. Your Honors, as you know, this case involves the limited circumstances under which an individual may be held personally liable for a taxpayer's failure to pay transaction privilege taxes under ARS 42-5028. In Arizona Department of Revenue versus Action Marine, the Arizona Supreme Court held that an individual may be personally liable if the individual assumed a duty to remit the taxes and the corporate taxpayer separately stated and then actually charged and actually collected the tax. This case involves the corporate taxpayer of Sanctuary Design. My client, Mr. Tunberg, was the CEO of Sanctuary Design during the relevant time frame. In 2016, the department filed a complaint against the Tunbergs seeking to hold them personally liable under Section 5028. After competing summary judgment motions in an evidentiary hearing, the trial court ruled that Sanctuary Design had not designated an individual responsible for the payment of taxes, and that Mr. Tunberg, as CEO, was automatically and effectively derivatively liable as CEO.
Counsel, how do you then, taking that, accepting what you're saying, as you said it, what happens when Mr. Tunberg talks to the people at ADOR, says, I had no idea that the CFO wasn't paying the taxes, I will take care of it. I will see that you are paid. Doesn't he assume responsibility for it at that point?
No, Your Honor, he doesn't, and for a couple of reasons.
Do you have a case on that?
I don't have a case on point, Your Honor, because
you.
the only case on point that we have really for instruction is Action Marine, which says that there must be something more than your position as CEO, right?
Well,
there must be.
But don't we have something more?
No, Your Honor.
He said, I will get them paid. I did not know that they weren't paid. I will get them paid.
I don't think he goes that far as to assume a duty in that single phone call, Your Honor. We're talking about a single phone call between the CEO of Action Marine and the auditor at the department, in which he says, effectively, in context of all of the broader notes, the taxes aren't owed, I'll put you in touch with my power of attorney, who happens to be the outside CFO. And when you look at the action notes, when you look at the call log notes, what happens here is there's a lot of communications with the outside accountant. There's one single phone call with the CEO, and then the remaining conversations happen with the outside accountant. Under the circumstances, Your Honor, that single phone call can't transform into the kind of duty that the Arizona Supreme Court said must be assumed. The Arizona Supreme Court said,
What does the record say about the size of Sanctuary Design at the time?
The size of Sanctuary Design at the time was roughly, it had grown from about 5 to 7 employees upwards of 25 or so. So there was a controller, an inside CFO, an outside accountant, and a managerial staff.
So there were 25 employees as of December of that year.
Roughly, Your Honor.
I'm forgetting the year, 2017?
I believe it's roughly around 2008, Your Honor. I'd have to confirm with the record at the moment.
Oh, at the time of the audit.
At the time of the audit, Your Honor, between 2008 and 2009.
So, and your client was the CEO,
Yes, Your Honor.
and I take it he was the owner.
Yes, Your Honor.
Okay. What's the court to do when there's no one who steps up and said, yeah, it was my job to pay, when you have a CEO owner who knows of the liability and doesn't pay it?
Well, I don't think this is an instance, Your Honor, where a person wasn't designated to perform this role. The only evidence we have in the record, and it's unrebutted, is Mr. Tunberg's affidavit, in which he states his role as CEO was big picture, strategic vision for the company. He delegated the responsibility of paying taxes, determining how to invoice, whether to separately stake taxes, either to the outside accountant or to his CFO. That's not disputed in the record, Your Honor. In fact, that's very consistent with what you see in the auditor's own notes, where he states multiple times over, the CFO who was hired failed to pay the taxes.
But the CFO, the buck doesn't stop with the CFO, does it, in this scenario?
No,
in that scenario, doesn't the CEO have responsibility to make sure that the taxes are paid? It's his company.
No, Your Honor, because if that were the holding, that simply the buck stopped at the CEO, it would transform what is otherwise a relatively narrow personal liability statute into akin to strict liability, which we know the Arizona Supreme
only
Court...
when the CEO knows and then doesn't take action.
I disagree, Your Honor. The Arizona Supreme Court said that something more must be... The individual to be responsible has to have control or has to hold, control, or otherwise assume a duty with respect to the taxes.
So the best thing that any corporation can do is appoint no one. Because ultimately, there's no one responsible, and it can't be attributed to anybody because the buck doesn't go uphill.
Well, I don't know if that's good policy or not, Your Honor, but what I can say is the Arizona Supreme Court has said this isn't strict derivative liability purely by virtue of your position as CEO. And we know that's the case because they said this isn't derivative liability in the Action Marine case. That's also the reason why they remanded to the trial court to have a factual development as to whether or not...
Didn't we have that here? I mean, what is our standard review of what the trial court found?
It's de novo in this case based on the summary judgment briefings. And what you have is Carl's affidavit, which is largely undisputed, consistent records in the department's own audit notes. And Your Honor, I'd point you to a couple of statements.
So then you would ask us to vacate summary judgment and remand it for a hearing on these facts?
No, Your Honor. I think based on the record that you have in front of you, you should enter summary judgment in favor of the Tunbergs. Based on the record below, there wasn't sufficient evidence at that time, based on the factual development, to hold him the responsible person. There were competing motions for summary judgment, Your Honor. What you should do is reverse the entry of summary judgment in favor of the department, enter summary judgment in favor of Mr. Tunberg.
Because your allegation is that the facts were in dispute.
Not in dispute, Your Honor. And in fact, I would point you to several admissions that were made in the department's answering brief regarding the standard of review, right, that it has to be an assumption of a duty, and also that it was the CFO, not Mr. Tunberg, who was the responsible person. If you look at pages 13, 14, 30, and 32 of the department's answering brief, the department concedes that it was Sanctuary CFO during the relevant time period that had the duty to remit the taxes.
But doesn't this become circular? I mean, yeah, okay, the CFO is the one that's supposed to have done it. The CFO quit. The CEO calls him up and says, I'm shocked by this. We owe the taxes, we'll pay the taxes, I'll get the money.
I don't think that's the kind of facts that you have in the record, Your Honor.
But where do we go from there? Where do we go from there? Do we say, well, but we can't hold you responsible because your nameplate on your desk did not say also responsible for CFO responsibilities if he's not present?
I don't think you need to make the decision today, Your Honor, about the outer limits of personal liability under the statute, given the facts that you have presented. What you have is a largely undisputed and, in fact, confirmed affidavit based on what's in the state's answering brief and in their own audit records. Under the circumstances, the unrebutted proof is that it wasn't Mr. Tunberg as the CEO. He didn't assume the duty. He had no idea how things were being taxed, whether tax was separately stated. And that's the kind of information, and those are the kind of facts that must exist in order for personal liability to attach, because otherwise you're transforming what is otherwise a very limited and narrow statute under which persons can be responsible for taxpayer liability into strict liability for the taxpayer's tax. That's the way it's handled for the taxpayer under Section 42, 5024, but not under 5028.
I'm just looking at you remember, I'm sure, that the court in Action Marine gave the trial court for remand a list of factors to think about. And one of them, it just seems to point to apply in this scenario where you've got a CEO who, the factor says, did the person have the authority required to exercise significant control over the corporation's financial affairs, regardless of whether he exercised such control? How can we say that in this scenario the CEO did not have the authority to exercise significant control?
So I think you were citing to the Ninth Circuit opinion in that particular portion of the Action Marine.
This is Action Marine, maybe quoting the Ninth
Yes.
Circuit.
The section in which that particular quote comes from is the part of Action Marine where they're talking about the kinds of different tests that might be useful for the trial court to employ upon remand. One of the citations is to a Ninth Circuit case, which is employing federal tax statutes, which are distinct from the kind of limited liability you have here. That's the very reason why the Intermediate Court of Appeals rejected those as persuasive, and the same rationale holds here. I think it goes too far to suggest that based on this sort of passing reference in a parenthetical in the last paragraph of Action Marine that is determinative of the standard here. It's also not consistent with the facts, because the facts demonstrate that this isn't a situation, as the trial court assumed, where there wasn't an individual designated responsibility. You don't need to make that determination of what happens in the absence or what the rules should be in the absence of someone designated, because both Mr. Tunberg and the department agree there was someone who was designated. So under the circumstances, the trial court's assumption, in effect, implication of derivative strict liability is not consistent with the standard articulated in Action Marine.
You're not saying that the CFO, after he terminated his employment with Sanctuary, continued to be liable for those taxes? Because you're saying that because there was someone designated, who was it other than the CFO who had already quit his position?
So the evidence demonstrates, and you can see this in the call log notes and also in Mr. Tunberg's affidavit, that at no time did he have that responsibility. It was either during
That's not
one
my
period
question.
I'm trying to get there, Your Honor.
Go for it.
At either one period of time, it's the CFO, and another period of time, it's the outside accountant. And that's consistent with what you see in the call log note, where Mr. Tunberg is saying, okay, taxes are owed, we'll get them to you. And then all of the communications after that single phone call happen with the outside accountant. So even under a scenario, Your Honor, where a single phone call could transform a CEO into the person responsible to assume a duty for purposes of personal liability under Action Marine, that duty would only have been held for that limited period of time in December, during which I don't believe in the record there's an indication that there are any contracts entered into.
So are you saying that the outside accountant actually contracted, you threw the C word in there, contracted to be responsible for the CFO's responsibilities when it came to the payment of taxes in the event that they failed to make them timely?
No, what I'm saying, Your Honor, is that what the record demonstrates is that it's either the CFO or the outside accountant, but it isn't Mr. Tunberg.
And we don't have anything in the record indicating that it's the outside accountant?
Other than Mr. Tunberg's affidavit, which indicates it wasn't him, it was either the CFO or the outside accountant who were responsible for the payment of taxes at different periods of time.
Except that he said, I will see that they were paid.
I don't think he said, I will see that they were paid. I think he said,
I'm going to get you the money.
he said, we will get you the taxes, or something to that effect. I'll pull the language, Your Honor, so I can be more specific on rebuttal.
Thank you.
But it goes to a broader policy issue, Your Honor, of encouraging individuals to have meaningful engagement with the department and to participate in audits. The argument has been that this single phone call and this participation by Mr. Tunberg in the audit process transformed him into the individual responsible for taxes for purposes of Action Marine. I don't think that we want to set, Your Honor, and I would suggest it wouldn't be good precedent to hold a CEO liable simply by making a phone call or simply by participating in an audit. We would want to encourage CEOs and officers and directors of entities to participate in a meaningful way in that process.
Good point. Let's talk about attorney's fees.
Thank you, Your Honor. Well,
let's say that, I mean, as I view the record, it seems to me that your firm incurred about $11,000 in fees up to the date of filing of the motion for summary judgment, out of the 68,000 total. So the vast bulk occurred after the mediation failed. And the issue as of the date of summary judgment was your client liable for the $93,000 in taxes? Not the 340, but the 93. If the dispute is between 93 and 45, or 40 something, how can you say that your client actually prevailed?
So, Your Honor, it was 340 or so thousand and change up until the time where the department switched and carved that down to the 96,000, because that's the additional charge. And then that 96,000, so what began as an attempt to hold the Tunbergs essentially liable for what the taxpayer would have been liable for, it dwindled down to around 96,000 and then went down to the ultimate award, which is around 46,000. That's from beginning to end, that's a 15% reduction, and from middle to end, that's a 50% reduction. I'm not sure if I'm answering your question, though.
Well, my question is, for the first year, nothing happened in the litigation. Nothing. And then there was a mediation, and then after that failed, it ensued. But from after the mediation, the dispute was between 93 and 0, and it ended up to be in mid-40s. How can you say that if, under that scenario, your client ought to win fees?
I don't think you can look at it in a carved down way. I think you need to look, Your Honor, at the totality of what happened from beginning to end. And my client shouldn't be penalized because there wasn't as much of a fact development between the 300,000 and the 96. But at the end of the day, I think, Your Honor, the question really is, who was the prevailing party? And under the circumstances, in the grand scheme of things, my client took it from 340,000 down to around 46,000.
What did your client do to take it from 340 to 93?
We demonstrated, Your Honor, at the evidentiary hearing that the department had failed to satisfy its burden of proving.
But from the point of the summary judgment on, the department was seeking no more than 93,000.
Correct. That's correct, Your Honor.
So that has nothing to. So you can't say that you brought it down from 340 to 93, can you?
I think in the grand scheme of things we can, but to your point, I think you can say between summary judgment briefing and the evidentiary hearing, it went half.
Did
Your
your
Honor.
client ever make a settlement offer?
I didn't participate personally in the mediation. I can confer with my
Well,
counsel.
that seems to be relevant to the fees application.
I believe that there was, Your Honor, but I can't give specifics on it at this point.
We're going to assume that your client didn't, unless you can say that it did.
If you'll give me a moment, Your Honor, and I can answer that on rebuttal.
There you go. Good.
I am at a stopping point, Your Honors. Thank you very much. I'd like to reserve the remainder of my time.
Thank you. Counsel?
May it please the court. Good morning. My name is Penny Moore, and I represent the Arizona Department of Revenue in this matter. First of all, I want to address a couple of the things that were brought up in the presentation. One of the things is that there was a discussion about the CPA and whether the CPA had a duty with respect to the taxes and remitting the taxes. The record is very clear that the CPA did not have a duty after at the beginning of 2008.
How was that memorialized?
It's actually in the affidavit of Mr. Tunberg.
So Mr. Tunberg recognized that the CPA did not have the response. He was not going to have to fill that slot.
That's correct. And
so
it
who would it fall to then? I mean, is it possible that a corporation can say we haven't appointed anybody, so we don't owe any taxes? Is there latitude for that?
That's not what that's not what the court said, the lower court said.
No, I understand. I'm saying, can they just simply ignore the issue of anybody being responsible for the payment of taxes?
I don't believe that that's the case. Do I have case law right on point? No, I don't. But what I will say is that you can have more than one responsible party as well. It's not like you're limited to just one. In this instance, we know for sure that the CFO had a responsibility to be filing and paying the taxes in 2008. There's no question about that. But we also know that the CFO did not do that. From the period of May 2008 to the period of December 2008, he did not pay. He did not file and didn't pay. And we know also that Mr. Tunberg became aware of that on December 16th, 2008, when he initiated a call to the Department of Revenue and found out. Now, maybe he knew earlier, but we know for sure that he knew at that point.
How did that call in?
It ended with him saying that he told the collector he was going to get the returns beginning, I think it was 5/08 to present to them. So it's not an exact quote, but pretty close. And so at that moment, he assumed a duty to get the returns, to get the taxes to the Department of Revenue. He didn't have to make that call. He made a call to let the Department of Revenue know, I guess, the address had changed, but that's when he found out that the taxes were not paid.
Well, your adversary, though, would say he was doing the good thing. He was being a good citizen. He didn't have to make the call, but he did. Does that one call make him liable for the whole shebang?
He didn't have to say that he would get the returns in either. He was the one that made that decision.
Is that what puts him on the hook?
He, at that point, said, I will get those returns to you. So he, on his own, took on that responsibility.
Is that
He
what
didn't
does it?
say yes.
As
At that point, well, it's not just that. He was also the manager. He was the managing member. He wasn't just a CEO. He was the managing member and the owner of this company. And he knew at that point that the person that he designated to get these taxes filed and paid did not do that. And he knew moving forward that it wasn't being done because he didn't designate the outside CPA to do that. That's clear in the record because that was done before 2008. He was done, the outside CPA. So it was either the CFO, who he knew no longer was not doing that, had not done that, or it was on him to either delegate to somebody else or, like he offered to do, he was going to do that. He could have delegated to somebody else. I mean, he knew this whole time then. This is the middle of the audit period. The audit period is May 2008 to September of 2009. So we're talking about the middle of the audit period. Now, when the audit comes around, he's very involved in the audit. He tells the auditor that, there was this this CFO that was supposed to file the taxes but didn't do so. I'm paraphrasing. But he knew long before that. He had a responsibility that whole time for making sure that the taxes were paid. He didn't have to do that himself. He could have delegated that. He was the managing member.
Okay, I ask opposing counsel, is there a gotcha in the statute for corporate folks to say, I know you're going to hate to hear this, but there's nobody here that's liable for it because we haven't appointed anybody? Is the lack of an appointment, the lack of something in the job title indicating that they're responsible, does that mean that nobody is?
That's not the case. I think that especially if the managing member, if that person knows that they're not being paid, they can't just say, we don't have to pay it, because as the tax court pointed out, that the entity, Sanctuary Design is just an entity. And so somebody has to actually file those taxes and pay those taxes. It's not like, we just don't have to do it.
So if the CEO had showed up at the audit and introduced you to the new, or CEO had introduced you to the new CFO and said, here's the person who I've now hired, a new guy, and he's now responsible, you guys wouldn't be coming after the CEO in that case?
It may be both. It depends on what the involvement was. In this case, we have a CEO that actually was involved. Do we file suit in cases against people that we believe are responsible parties because they have communication with the Department of Revenue regarding taxes? Yes, we do. Do we go after them when they sign the returns? Yes, we do. Because what we do is we build on what kind of involvement did they have. Now, his involvement didn't stop there. He was very involved in the audit as well. And remember, that started September of 2009. So at the end of that audit period, they still hadn't paid. That whole time, he still hadn't paid.
Understanding the significance of the fact that after the audit commenced, Mr. Tunberg was involved. And that shows he was talking to the department. How does that make him responsible for paying the taxes?
It wasn't that he was just involved. He was intricately involved in that audit. Remember, the taxes still hadn't been paid. He knew that they hadn't been paid. Here we are. We're at a place where the department is auditing Sanctuary, for whom he's the managing member and the CEO. He knows they haven't been paid, but he's yet involved in meeting with the auditor and talking with the auditor about the amount owing. was never protested. They didn't dispute the amount that was owed.
Is
And
it the fact that he knows the taxes haven't been
Yes.
paid that puts him on the hook?
yes,
Can I ask you an extension of the judge's question? Did Mr. Tunberg, and I don't know how much detail you can give me on this, but did Mr. Tunberg just go to the meetings when they were doing the audit and just sit there and smile? Or did he answer questions on behalf of Sanctuary or provide information that maybe filled in some of the gaps in what they were looking at? Because I know there were some substantial gaps. What was his purpose in being in the audit, involved in the audit, which I would assume was a CFO responsibility?
Your Honor, the record shows in the audit notes that he participated in terms of being there in their discussions, because there were other people from his office as well. In those meetings, there were discussions with the auditor. The actual draft of the audit was given personally, hand-delivered to Mr. Tunberg for his review. So, somebody who's not involved in the audit, but yet not involved in taxes, was personally given the audit for the taxes to review that, to make sure, that everything looked accurate. They never protested afterwards. So he was involved in talking with the auditor. They discussed the taxes. They discussed, how things were calculated, amounts that were owing, things like that. So, he was more involved than a CFO who was back in his office and letting people he delegated the process to handle it. So he was involved just as much as the people who were there that he had sent.
I think Judge Johnson's question earlier triggered something in my mind, and it may be what she was getting at, but why does his involvement in the audit matter as opposed to his lack of involvement earlier when the taxes were actually withheld from the people who paid? Why is that the measuring time?
Well,
and not the time that the taxes should have been transmitted previously?
I would argue that it's both times, because he was aware halfway through that audit period when those taxes were due and owing. He was aware that they were not being filed, and didn't do anything. Told the department he was going to, but didn't do anything, nor did he delegate to anybody else to do it. Then you get all the way to the end of the audit period, the money is still owing. It's not like we're done now with that audit time frame. The money is still owing. That money was never paid by Sanctuary. After that audit was done, it still wasn't paid.
Was Mr. Tunberg deposed?
No, he was not.
So we don't know whether he regularly reviewed the company's books, records, financials.
No, we don't know that. But on the other hand, he was the managing member. And so there was no one that was higher than him. And, he was the owner, as my counterpart testified.
Let's talk about attorney's fees. How do we know what cases tell us? I mean, in my hypothetical, I'll start where I ended with your adversary. If you're talking about a claim for only $93,000 that ends in a judgment for $40,000 odd, what tells us whether the defendant in that case was the prevailing party?
Well, the case that we cited, Your Honor, was Corley. And it's Corley versus Arizona Board of Pardons and Paroles. And in that case, the statute said, under the statute, they said that a party is a prevailing party if it prevails by an adjudication on the merits. And we know that there was an adjudication in the summary judgment motions and also in the evidentiary hearing.
Well, that's not my question. It's the amount of money involved. The demand for $93,000 resulted in
$49,000. Correct.
Let me pitch you a hypothetical.
Okay.
If they had gone through everything exactly the same except that the final judgment was for $1, would you have been the prevailing party in that case? Or would they have been the prevailing party?
I'm sorry. Say that again. I didn't
Court,
follow you.
everything exactly the same except that the tax court says, you know what? There was only $1 actually withheld, so that's all I'm going to order Mr. Tunberg to pay. Who was the prevailing party in that situation? Or who would have been the prevailing party?
I can't answer that because if I don't understand it's not that I don't understand your question. I would need to know kind of how it resolved to that $1. So
They said you did not, exact same
we were
factual
successful,
scenario.
but it was just $1.
They said the court said all you proved up was that $1 had been withheld and not transmitted. This is not difficult, so
Yeah.
you need to answer this question.
Okay, so to me, it would mean that we would not have proved all of,
Right, you
Be-
failed, you did not meet your burden of proof, and so only
because-
$1 was, the taxpayers were ordered to pay you $1.
in that instance, I would think that we were not the prevailing party because we would not have proved that, many of the contracts were paid, that they
Okay.
did pay
So now
it.
So
you
how
know where
about-
we're going to go with this.
Yeah, so how about $5,000?
Yeah. Well, in this
You sought
instance-
95, the court says you proved up 5,000. Did you prevail or did they prevail?
Well, I would say it depends on how much, we had sought. Like in this case, I would say that at least 50% would be an amount that would be, we'd be the prevailing party.
Okay. Did the trial court apply that analysis, the 50% plus, that would make sense to me. Maybe a preponderance of the evidence is the kind of thing we use. Did the trial court apply that?
What the trial court said, is the fact that a party did not recover the full measure of the relief requested does not mean that he is not the successful party.
Which seems
So
to
he
be
was
wrong
quoting
based upon what
Ocean.
you said, because if it had
Yeah.
been down to $5,000 or $1,000, then they probably did prevail.
Yeah.
And I'm not sure you got 50%.
Well, we did get 50%.
Barely, okay, yeah,
Yeah, it was
49,700.
53%. Actually, it was 53%.
Thank you for
Yes.
And there's a subsection or a sub-analysis on that maybe once you determine the prevail, you move to subsection C of the statute and determine kind of reasonableness of the party's positions and all that type of factor. But just the threshold thing to prevail, it seems like the court needs to say they won or they lost, not just that there was a judgment entered against them, right?
Well, the judge did determine that we were the prevailing party.
And it said that although they got it substantially lower, there was
Yes.
still a judgment entered against them, which does not seem to be the standard.
I can't speak to the judge exactly because the minute entry was not, it didn't give all that analysis, so I can't speak to what the judge actually did.
Well, where do we look for guidance about how to answer this question? What tests should the trial court look to in a case like this, where 2x is sought, 1x plus $1 is received? How do we know whether 348 applies in that sense? What's the test, and what case tells us that?
I don't have a case on that. That's not, I didn't, because that wasn't what the judge focused on. That's not something that I look to.
Well, the court though talked about the net winnings rule. I'm not understanding how that applies in a tax case, where if the department is either going to recover something or it's not, but the taxpayer is never going to recover anything. So I don't think the net rule applies, does it?
I believe that it would apply. I don't know how that would be
then
different.
walk me through how the net winning rule applies.
Well, in this instance, it would be, if you, the adjudication on the merits, the amount that you had prevailed on, that you had won was more than the 50%, then that would be, in terms of attorney's fees, you would have prevailed.
So you think the net winning rule means in this scenario, if the department wins more than half of what it ultimately sought?
In the summary judgment motion, the adjudication on the merits.
Why do you focus on the summary? I know why you focus on the summary judgment motion, but why should we focus on the summary judgment motion as opposed to the $340,000 you initially filed for?
Because when you file a lawsuit, you have the information that you have presented and you file your suit. But as you go through the process, you then can make determinations and do make determinations about what you have, what all the evidence that you are able to gather and have that information. And so in the process, in this case, we did have a settlement conference. And so it was in that settlement conference that we talked about the contracts, and the contracts that specified the tax amount in the contracts. And so it was at that point that I agreed with opposing counsel that the amount that we could prove would be $93,000. A little
Be
bit
no
over.
more than 93,000.
Yes,
That's already,
correct.
I mean,
And
if they had taken that right then and said, all right, we'll take $93,000. And I'm not, we can't tell from this record whether there was an offer or whether, they assert that you guys said we can't even settle for that amount and then turned around and accepted that amount. I don't know what happened. But if they had accepted that amount right then, under the net winnings or whatever you want to call it analysis, they reduced it from 340 to 93. That's more than 50%. So why wouldn't that be a prevailing measure for them right then?
Well, in that instance, it wouldn't have been an adjudication on the merits because we would have
Oh,
settled.
4501 says if you'd settled and there was a judgment entered right then, it would have been an adjudication on the merits.
If there
4501
had been a
North.
judgment entered. But if it was just a settlement, there wouldn't be a judgment.
Well,
It'd be a settlement that would be filed.
there would have been a dismissal of the case
That's
based upon
correct.
the settlement, and
Yeah, that's
we'd
correct.
be litigating whether that meets an adjudication on the merits. But
I agree.
if they-
I understand what you
so,
mean.
and I think this now moves to, and I'm tipping my hat on where I'm thinking, but it seems now that moves to kind of bifurcating the analysis. And so maybe the court would say, the trial court should say 340 to 45, they prevailed, but we're going to look at it and say they only prevailed under the reasonableness of the attorney's fees. It wasn't unreasonable for you guys to take that position here, and their position. Do you see what I'm getting at? Is that it seems to me that talking about 50% only from the summary judgment ignores a major portion of the litigation, even though it wasn't as costly. The whole first part of the litigation, even though it wasn't as costly, it was there. That was what you guys sought. And yes, you took a reasonable position in reducing it down at some point, but why should that change the measuring point for whether they prevailed when you initially sought $340,000?
I think it's because of Corley and how it's in an adjudication on the merits, which in this case was a summary judgment, both their summary judgment and our summary judgment, and also the evidentiary hearing to determine the exact amount that was collected, and that's what the trial court did in the evidentiary hearing. So those were where that determination of how much tax was actually collected, that's where those were decided. So we would not know that at the time that we filed the complaint. I mean, at the time we filed the complaint, we had the audit and we had evidence of the responsible party and that kind of thing, and the amount that was in the actual audit itself.
Did the department make a settlement offer?
We did not make a settlement offer.
Did the other side make a settlement offer?
No. And I think my time is up.
Thank you.
All right, thank you.
Thank you, Your Honors. I'll begin where we left off with respect to the mediation. The initial demand at the mediation was the $340,000. There was a discussion at mediation regarding the maximum amount theoretically possible that the department could obtain at the $96,000 or so figure. The department didn't come down off of its position with respect to the 340, and there were no offers made.
How would they determine? Seems to me that 340,093 is a big difference, especially if it's the state saying this is a taxable issue and we've established, right?
The $340,000, which was sought in the initial complaint, is exactly the amount, the factored amount that they came to for the taxpayer's liability, and that was the product of the initial audit of sanctuary
When you say
design.
taxpayer in that case, you mean the corporate?
Yes, Your Honor, the corporate taxpayer. So what they did is they conducted this audit. They came to the conclusion that the corporate taxpayer, Sanctuary, owed around $340,000, and they sought the identical amount from the Tunbergs as responsible persons. But responsible person liability isn't the same as the liability for the corporate taxpayer. So it was incorrect from the get-go. That issue was discussed during the mediation. The positions weren't changed. It didn't change until a summary judgment briefing was filed.
The fee statement reflects, as you would expect, some disclosure going on before the mediation and the settlement conference statement. Very Did your client offer documentation, offer documents and disclosure before summary judgment that would have caused the department to come down?
I believe that all of the contracts had been disclosed, and when I say contracts, I'm using that word
That-
loosely, the bids that they used to identify the taxes. It was the department's position.
The 6 contracts that ultimately become the basis of the 40-some thousand.
Yes, I mean, calling them contracts, our position would be that's a bit.
They do say contracts
generous.
on them.
Some of them say contract, but it's the construction industry, so you're having changes in invoice, et cetera, moving forward. I'm mindful of the fact that I don't have a lot of time left, and I do want to address some of the points. Would you like me to address anything further on the fee? Okay. There were a couple of points made by the department that I'd like to address. First of all, there was an assertion that Mr. Tunberg's status as managing member meant that he was the person responsible. It's not what the statute said. If the statute said that the managing member or the officer or the director is responsible, the department might have a point. That's not what it says. It says the person, which Action Marine says must be someone who assumed a duty. So the status as managing member isn't sufficient. Second of all, the department's taken the position that mere knowledge that taxes are owed is sufficient. Again, knowledge of taxes being owed is not the standard under 5028, nor is it the standard that was articulated in Action Marine. So the simple fact that at some point in time during a single phone call there's reflected that Mr. Tunberg knew that taxes were not paid and owing isn't sufficient to transform him into the person responsible because it doesn't reflect the assumption of a duty.
I didn't hear the department argue that it was just knowledge. I heard her say it was knowledge combined with participation in the audits, combined with his role and the fact that he didn't appoint someone else to do it. I heard a broader argument.
So, and I may have misheard it, Your Honor, but with respect to knowledge, that's certainly our position. With respect to who was and wasn't appointed, I direct you to paragraphs 10 and 11 in Mr. Tunberg's affidavit, which describe his role in the company as having no involvement whatsoever in tax and accounting functions, and the description of who was appointed to perform those functions and when. Your Honor, there's been an assertion that Mr. Tunberg was very involved in the audit. I think that if you go back and review the audit notes and records, you'll see that he participated in around 2 meetings. It was a very limited involvement. Most of the involvement was the controller, the manager, and the outside CPA. And again, our position is that participation in an audit during the audit period can't transform you into the person responsible. And at the end of the day, I know, Judge Jones, you had some questions about the circumstances. What happens when an entity just doesn't appoint someone? I don't think you need to get to that question and answer that in connection with this case, given the evidence in front of you. But at the end of the day, the statute says what it says, and Action Marine interpreted it the way that it did.
So they
and
can't
this isn't
simply walk away and say, we never appointed anybody, too bad for you.
the taxpayer is ultimately on the hook for liability. This particular statute, it's an exception from the broad rule that, officers and directors are generally not liable for the conduct and the debts of the corporate entity. It's a narrow statute that the Action Marine Court interpreted narrowly. It's a departure from this general insulation of liability. This isn't a situation where no one's on the hook, the taxpayer's on the hook.
We've been assuming and talking about the CFO as having left, no longer terminated, whatever. Is that right? He was no longer at the company during the audit period?
He did leave at some period of time between 2008 and 2009. I don't have the exact date in front of me, Your Honor, but I believe it is in one or more of the affidavits that Mr. Tunberg submitted.
Okay.
Thank you, Your Honors.
We were curious. How's that? Gave you some questions. Thank you very much. These are always helpful to us, and we appreciate your time today. We're going to take the matter under advisement at this time. As I'm sure you heard before, we will rule in due course. Thank you. We're adjourned.